Should women be allowed into Kerala's Sabarimala shrine? The Supreme Court Constitution Bench will hear the matter starting today. The Modi government moves to amend the Right to Information Act in the monsoon session of Parliament. Activists say it's aimed at diluting the transparency law.
The first time in my life I have someone screaming, "Daddy, Daddy."
And in case you missed it, Wimbledon champion Novak Djokovic speaks of his biggest motivation in his return to winning ways. It's Tuesday, July 17th. Does the restriction on the entry of women into Kerala's Sabarimala temple amount to discrimination? Is the exclusion of women an essential religious practice? These are some of the questions the Constitution Bench of the Supreme Court will be seized of as it begins hearing the matter on the entry of women into one of India's biggest pilgrimage centers. Let's get you a brief background. Women between the ages of 10 and 50 are not allowed in the shrine. It is widely believed that is because the presiding deity Ayyappa is celibate. The temple's management had earlier told the Supreme Court that women of menstruating age can't be allowed on account of purity. The petition in the Supreme Court points to an earlier decision of the Kerala High Court in favor of the practice to underscore how it was, among others, based on gender stereotypical premises that women are impure and polluted during their cycle of menstruation. In October last year, a 3-judge bench of the Supreme Court had framed a set of 5 questions for the Constitution Bench to consider. Let's try and understand them. First, whether the exclusionary practice, which is based upon a biological factor exclusive to the female gender, amounts to discrimination and thereby violates the very core of Articles 14, 15 and 17. Articles 14 and 15 pertain to equality before law and the prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Article 17 bans the practice of untouchability. Lawyer Gautam Bhatia had inferred that in framing the question, therefore, the court has at least acknowledged the possibility that banning women on grounds of menstruation creates and perpetuates a stigma that is similar in character to the stigma faced by caste untouchability. Second, whether the practice of excluding women constitutes an essential religious practice under Article 25. Now, Article 25 states that all persons are entitled to the right to freely profess, practice and propagate religion subject to public order, morality and health. Now, the essential religious practices test first found mention in a 1954 case in the Supreme Court. The court here said what constitutes an essential part of religion will be ascertained with reference to the tenets and doctrines of that religion itself. So the question before the court, is the banning of menstruating women an essential religious practice or a peripheral one? Third, whether Ayyappa temple has a denominational character, and if so, is it permissible on the part of a religious denomination financed out of the Consolidated Fund of Kerala and Tamil Nadu to indulge in such practices violating constitutional principles? Now, Article 26B is where the Constitution guarantees every religious denomination the freedom to manage its own affairs in matters of religion. So can Sabarimala, which is governed by the Travancore Devaswam Board, which is a state institution, be considered a religious denomination? Questions 4 and 5 are connected, whether Rule 3 of the Kerala Hindu Places of Public Worship permit religious denomination to ban the entry of women between the age of 10 and 50 years. If so, would it not fall foul of Articles 14 and 15, which is restricting the entry of women on the grounds of sex? The Rule 3B of the Kerala Hindu Places of Worship rules is ultra vires of the Act itself. In 1965, the Kerala Hindu Places of Worship Authorization of Entry Act was enacted. Under Section 3 of the Act, places of public worship must be open to all sections and classes of Hindus, notwithstanding any custom or usage. Section 4 deals with the power to make rules for the maintenance of order and due observance of religious rites and ceremonies, provided that no rule or regulation shall discriminate in any manner whatsoever against any Hindu on the ground that he belongs to a particular class. Under powers of Section 4, the Kerala government frames certain rules. Rule 3 bars certain classes of people from offering worship, and this includes women at such time during which they are not by custom and usage allowed to enter a place of worship. So the question being asked here is, doesn't this rule barring women run contrary to the main act which throws open places of worship to all sections and classes of Hindus? Net, these are complicated legal questions which in effect will decide if Article 26b, the right of a religious denomination to manage its own affairs in matters of religion, can be allowed to override the individual freedom of women to freely practice religion as guaranteed under Article 25(1). At last count, as per the Commonwealth Human Rights Initiative that has been mapping attacks on Right to Information Act users, 73 people have been killed, allegedly for seeking information under the RTI Act. Now, if a proposed set of amendments to the RTI Act were to go through, activists say it could provide a perverse incentive to vested interests to silence the information seeker through coercion or physical harm. The proposal is reportedly to allow for the withdrawal of appeals based on a written communication by the appellant and closure of proceedings upon death of the appellant. The RTI Act currently does not allow for the appellant to withdraw their appeals. The fear is that RTI applicants who already face threats could be rendered further vulnerable to violent coercive tactics. Now, the bill to amend the RTI Act has been listed for the monsoon session of Parliament that begins Wednesday. But the government has not put the draft amendment bill in the public domain yet, going against established procedure and inviting all-round criticism for the lack of transparency in amending, ironically, the Transparency Bill. Other contentious amendments the government reportedly plans to bring that activists say would dilute and further reduce the efficacy of the RTI Act are: the central and state governments will decide the salaries of information commissioners. This, activists say, would adversely impact the ability of the information commissions to function in an independent manner. Another one is making it mandatory that each complaint be accompanied with a copy of the RTI application submitted to the Public Information Officer. Now, the RTI Act provides for filing a complaint in cases where a Public Information Officer has not been appointed or where a Public Information Officer has refused to accept an RTI application. In such cases, the complainant would not have a copy of the RTI application submitted to the PIO. Another proposed amendment is that a complaint be filed within 90 days from the date the cause of complaint arose. Now, activists say since violations of the RTI Act, such as being provided false information, may only be proved much after the information has been furnished, the Act has not prescribed a time frame for filing complaints. A Change.org petition urging the government to drop the proposed amendments reminds the Prime Minister of his promise to make India corruption-free and asks, why then is this government bringing regressive amendments to one of the most powerful ways to fight corruption, empowering people with the right to information? 200 people dead, a dozen still missing, murky brown floodwater swirling, enveloping everything in its pathway. With close to 12,000 people still staying in evacuation centers across 15 prefectures, Japan's massive July floods, reports say, are the country's worst weather disaster in 36 years. The worst hit are Kurashiki and Mabe cities, along with Hiroshima and Matsuyama. The region received near-record rainfall of 132.5 millimeters on July 6th, the highest in 7 years. The Odagawa and Takahashi rivers that flow through the region swelled, breaking embankments and unleashing floodwaters. The constant rains, coupled with elderly residents who often didn't understand the risk warnings, and a delayed evacuation order resulted in the steep number of deaths. While several experts blame the river, locals blame authorities. The area, home to an elderly population which cannot evacuate easily, sees knee-high flooding every monsoon. Locals have consistently warned that this could increase and made demands for the construction of a small dam to reduce flood risks. Their proposals were approved in 2014, but the actual construction of the dam was delayed to start only around November this year. And in case you missed it, here's one of our favorite moments from Sunday's Wimbledon's men's final.
The first time in my life I have someone screaming, "Daddy, Daddy." And it's a little boy right there. He's under 5 years old, so he couldn't watch the matches live, but we were hoping that if, happens, if I hold a trophy, that he can be there to witness it. So I can't be happier. I mean, I'm very emotional for him being there.
And with someone as adorable as little Stefan watching, it isn't a wonder that Daddy Djokovic, who had been battling bad form, injury, and had dropped to his lowest rank ever this year, played his heart out and won his 13th Grand Slam title. You too stay inspired. Bye for now.